an injunction application, and that was by Imani African security expert Kwesi. They sought to restrain the president from removing the IGP and other security heads until the substantive case is determined in May 2025. The five-member panel, presided over by Justice Bafoboni, they held that the presidency, the pendency of the case, I beg your pardon, it shouldn't stop the president from carrying out his administrative duties. When the case was called, counsel for the plaintiffs, lawyer Kofi Bentil, he attempted to move his application to injunct the president's removal of Dr. George Kufuor-Dampare, but the court drew his attention that his request would no longer hold and be actionable since any African Professor Kwesi, he was not pleased with the decision of the court eventually. We have on the phone lines Kofi Bentil. He was counsel for the plaintiffs. And I'm talking about Imani Africa and Professor Kwesi. Counsel, thank you so much for making time for us this morning. Based on the application you sent to the court and the ruling of the court, you're clearly not happy about it. What effect do you think this ruling has on the security architecture or the powers of the president going forward?
Good morning to everyone. So first, you said I was not pleased with the ruling of the Supreme Court. I think there's a bit of a difference there. I understood the ruling of the Supreme Court.
Right.
I wanted them to do a bit more. You must understand that an injunction is supposed to prevent something from happening. So it's like you and somebody are fighting over something, and you say it belongs to you, the other person says it belongs to them. So an injunction is supposed to say none of you should take it until the matter is settled. But then you come back and the other person has taken it. That makes the injunction moot ab initio because the thing has happened. So I understood what the Supreme Court said. However, once it had happened, the effect will be for me to withdraw the injunction, and then we wait for the main judgments to be, issued. But I explained to the Supreme Court that I will not withdraw it because I think what has happened is wrong in itself. And I was urging the Supreme Court to do a number of things which they had the power to do. And if they did that, I would have been happier. But they chose not to do it, and I understand that. What I was saying was that when somebody has a case before a Supreme Court like ours, that person is not supposed to overreach the court and do the exact thing that they are being asked not to do in the injunction. That's the rule. You don't have the time for me to go through it. But when a matter is before a court, you are supposed to hold your hand and not do anything to overreach that court. Now, with the injunction pending, the president still went ahead and removed the IG. That was an affront to the court. Right. And I wanted the Supreme Court to make a note of it. Secondly, when you take an action like that, which is self-serving and is seeking to defeat the ends of the court, the Supreme Court has the power to set it aside. And I was urging the Supreme Court to do that because we have three arms of government. And you have one arm of government basically trying to oust the authority of the other arm of government. That's the court. And I wanted the court to assert itself. In other places, there are cases like Madison where the court asserts its own authority to override what others do. So that is what I was working on and trying to say that, look, you have authority to do this, so please do it because it's good for the country. Then I was also trying to make the point that even the removal of the IGP, and by the way, it was not just about the IGP, it was about all service chiefs.
Right.
But the one that moved us to court were the rumors that the IGP was about to be removed. And indeed, our suspicions were well founded because that is exactly what happened. But that removal itself, I was arguing, was unlawful because of the provisions in the Constitution and the Police Service Act and CI 76 and all those other things. Secondly, the removal was irregular. You have a spokesperson of the president signing a letter, which was not delivered to the IGP. It was posted on social media. It wasn't clear whether the letter was a dismissal or a retirement or a reassignment. And in that letter, they referred to the IG as a COP. The IGP is a rank according to Schedule 2 of CI 76. So if you reduce the person in rank, you have demoted the person. And the Constitution says that you cannot demote or sack anybody without just cause. So that letter itself was unlawful ab initio based on applicable laws. So I was urging the Supreme Court to make a note of that point and say, because of all of these things, we are going to set it aside. Okay? Now, these are a lot of arguments, and it took a long time, and we have very respectful, banter back and forth. I understood their position. They understood my position. I was urging them to do something which was not usual, and they declined to do so. So in the end, all they said was, look, it has happened already. Whatever happens on May 7th, it shall affect the future. But as far as they are concerned, my understanding was that what the president did is not unusual based on what other presidents have done. And to the extent that the president believes that what he's done is right, only the Supreme Court can tell him he is wrong. And that day will come on May 7th. And if on that day, the Supreme Court decides that he is wrong, whatever follows is for the future. So as far as they are concerned, they will want things to settle. And for that matter, they will not grant an injunction over a matter that has happened already. That is why I was explaining that when you say I was not happy with it, it's not exactly accurate because I understood what they were saying.
Right.
I was just doing my job as a lawyer to push these new angles and to hope that the Supreme Court will, take their Margaret and Madison moment, and then send a message that you should not overreach the court when your matter is before the court. And there are many cases to that effect. So what happened was interesting to this extent, but honestly, I do understand how the ruling went.
Counsel, so going forward, we're waiting for the judgment on May 7. But whichever way the judgment goes, what prospective effect will it have on the powers of the president in matters like this?
Okay, so what we are arguing before the court is that certain things have gone on for many years in this country. And it has happened because we were under the impression, when we are in the country, or maybe the president, was under the impression that they have the power to remove the heads of the service institutions, fire service, police, and all those things. Now, they do not have that power. That suggestion comes from the idea that since they appoint, then they can remove. But there are many officers in this country, for instance, judges, where the president appoints, but the president is not the person who removes. There's a process of moving. Today, you've seen news that some people have made a petition for the removal of the CJ. The CJ is appointed, but when it comes to removal, a different process ensues. And the suggestion has been that because there is no clarity about how to remove fire service chief or immigration head or prisoners head or IGP, then the president can simply remove him with a letter. What we are explaining to the court, and if you read our writ, it's all there. There is a public document, you can find it and read it. We are saying that in Article 190 and 191, the police service is part of the public service. And the public service is protected under the Constitution. And the protection is to the effect that no person in the police service, fire service, whatever, can be punished or removed or any such thing without just cause and due process. And that covers also the IGP and all the heads of the security services, the chief fire officer, and all those other people. The person that it doesn't cover is the army or the chief of defense staff, because the president is the commander-in-chief of the army. So all these other people may not be removed except for just cause and due process. And we have stated all that, we have explained it. Now, the problem is that these laws concerning these service chiefs are spread out in the Constitution, in their own enabling act, and a few other places. And what we are asking the Supreme Court to do is to interpret them together. Because if you interpret them together, you will come to the conclusion. that the president may appoint an IGP, but he is not the one to remove an IGP. Because the IGP is a rank according to the second schedule of CI. And you may not remove or demote or punish or dismiss a ranked officer of any of the security services without just cause. So if the judges of the Supreme Court agree with us, it will cure the wrong notion that the president who appoints is the one who can remove an IG. That problem has caused a certain situation which was not intended. And the situation is that now our IGs rotate with the politicians. Security should not be that politicized. Security is a generic issue. If there's insecurity, it affects everybody, regardless of your party. So their officers must not be coterminous with the officers of the president.
Right.
And that is what we have ended up with. And that is not what the Constitution intended. And that is why we are asking the Supreme Court to interpret it clearly so that in future, presidents will stop messing with our services. In essence, that's what it is.
Kofi Bento, thank you so much for your time with us this morning. We're grateful, so grateful for your time with us in the program.
Thank you, too.